So I wanted to address this.
Terrible maze,
You
right?
can be,
That's it. So I don't know what that has to do with it.
but
I'm not a family court, so I don't know what
Yes.
that means.
But my point being is that I'm only trying to address these as far as bond and to have a court date next week so that he will be available to go to the pretrial hearing for the case where she hit him with her car.
Allegedly.
Allegedly.
Thank you.
Yes, yeah.
So
Well,
that's set for the 8th.
that is set for the 8th. So if we can have a 1-week adjournment.
Any objection to it out there? At this point, I'm going to deny the motion for bond reduction or modification of bond. Let you take a look at that other report, see whether or not that other report is relevant to.
Court seating, Courtroom County, Washington, State of Michigan is now in session. All those having business before the court draw near, I'm dedicated.
You may be seated. Good morning, Mr. Cook.
Morning, Your Honor. Raymond Cook for the people. Your Honor, you believe any potential conflict between this honorable court and the office of the public defender. Both people do not believe that any such conflict exists. You make this waiver in the avoidance of all doubt.
Morning, Judge. Court shall feast to first assistant public defender. We likewise.
Why were you?
I'm looking for my boss.
What?
Looking for my boss. This is normally what she does. Scans.
Oh, where is she?
I don't know. She was here a second ago.
I like her better than
I know. That's why I'm going to find her for you, Judge.
thought I'd point that out. But go ahead. I'll hear.
Thank you, Judge. We likewise do not believe that the conflict exists, but should a conflict arise, we would waive said conflicts for any and all cases before this honorable court today. Ask this court to please hear them, Your Honor.
The court, for its part, also does not believe that there's a conflict either in the court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Derek Stewart. Well, before we go ahead, is there a new report in Mr. Stewart's case?
Joy Gaines, Senior Assistant Public Defender. Yes, there is, Your Honor. We received a report last week before last.
Because I don't have a copy of that report.
I can,
Was that a report finding him competent?
that is correct, Your Honor.
Can you send that? Let me pass it briefly. Send that to Ann. She'll get it to me, and that way I can review it and we can handle it today.
Okay.
All right. Mr. Stewart, I'm going to pass your matter briefly, okay? All right. Thank you, Mr. Stewart. Court calls the case people versus Wilnisha Crosby.
Morning, Your Honor. Ashley Phelps for the people.
Morning, Your Honor. Assistant Public Defender Davi Liba form is Crosby, and I do have a green sheet.
All right.
Good morning, Your Honor.
Crosby,
Wilnisha Crosby, how you doing?
I'm doing great. How are you?
Okay, could be better.
Yeah, I got it. I don't even know why I asked, right?
Yeah.
You're seeking to adjourn this?
Yes, Your Honor. I've reached out to the Wayne County Jail and left a message, but unfortunately, I haven't yet been able to actually have a meeting with SB.
And how much time did you need? 2 weeks or 3?
I would hope we could get this done in 2 weeks, Your Honor.
Probable cause conference in this matter then will be adjourned to May 7th, 2026, 9 a.m. Bond will continue.
Thank you.
Thank you.
Mason.
Court does call the case people versus Anthony Reeves.
Your Honor, Raymond Cook.
Yeah. Or Alan can get it. I'm sorry. I didn't mean to.
Yeah, Robert, go off after Anthony Reeves. Anthony, would you state your name for the record?
Yes, my name is Anthony Lamar Reeves.
Thank you, sir.
Judge, I don't have all the discovery yet. I should have it this week. Hopefully I can arrange a visit with Mr. Reed in Lapeer the correction facility. Could we adjourn? Is it possible to adjourn this out about 3 weeks?
I don't want to adjourn.
I'm sorry?
I don't want an adjourning. I want to go for a dismissal.
You want
Want to
to?
do what? It can't be dismissed at this point, sir.
You say it can't?
It cannot, but your attorney is indicating he doesn't have all the discovery to be able to talk about the case with you.
Well, I ain't got a chance to can I
Okay.
get like a second to talk to the attorney before y'all adjourn? Because I don't really want to adjourn this to 3 weeks.
Okay.
Mr. Reeves, if you would let me adjourn it maybe 2 weeks, I could hopefully set a visit for you and get you to discovery. I know you're anxious to deal with this, but you and I need to talk about the case.
How about 1 week, man?
Well, I can't do 1 week. This isn't a negotiation, really. I can't do 1 week. The shortest period is 2 weeks because we have to do a video writ for you. But that's the best. If you're looking to speed this up, that's the best we can do.
All right.
Probable cause conference, May 7th, 2026, 9 a.m. Beth.
Thanks.
Court calls the case, People versus Terreno Rogers.
Morning, Your Honor, Raymond Cook for the people.
Torino Roger, Your Honor.
Assistant Public Defender Davi Leba on behalf of Mr. Rogers.
Mr. Rogers, state your name again, sir.
Torino Smalley Roger, Your Honor.
Thank you, sir.
Your Honor, I'm going requesting adjournment. I have not been able to meet with Mr. Rogers. However, I do have that set up for tomorrow.
Use what?
I do have that set up for tomorrow.
Tomorrow you're going to meet with him?
Yes,
So 2 weeks would be good.
that'd be perfect, Your Honor. Thank you.
7, 2026, 9 a.m. Bond continue. Court does call the case of the People versus Evan Sherbert.
Morning, Your Honor, Raymond Cook for the people.
Assistant Public Defender Davi Leba on behalf of Sherbert.
Sherbert, can you state your name, please?
Again, Evan Sherman.
All right, I have before me a plea form. Is that what we're doing today?
It is, Your Honor.
Plea form indicates that the defendant will be pleading to the stated count to receipt concealment of stolen property, 200 to 1,000. That's a 1-year misdemeanor. Upon a successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor.
Correct, Your Honor.
All right. Sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name, please.
Evan Sherman.
All right, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of receipt and concealment of stolen property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court.
Yes, Your Honor.
Still wish to plead guilty?
I couldn't hear you, I'm sorry.
You still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Yes.
I didn't hear you, sir.
I couldn't hear you, I'm sorry.
Okay. To that charge, how do you plead?
Guilty, Your Honor.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or had one signed on your behalf. Is that correct, sir?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
I do not, Your Honor.
Do you understand that you're waiving all those rights, including your trial rights, which are contained in paragraph 5?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you are indeed guilty?
Yes, Your Honor.
September 3rd, 2022, at the location of 9429 Main Street in Northfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty of this offense?
I went to a storage locker and taking some items, brought them back home.
You are echoing there. So you rented the storage locker. Did you have stolen items in that storage locker?
They were at my house. From the storage
So
locker.
at some point, you came into possession of stolen property.
Yes, Your
Is
Honor.
that correct?
They were found at my
All
house.
right. And you knew that it was stolen.
Yes.
All right. And you tried to conceal the whereabouts of that stolen property from its rightful owner and or authorities. Is that correct, sir?
Yes, Your Honor.
All right. And was the value of the property that you were concealing, was that in excess of $200?
I believe so, yes, Your Honor.
All right. Counsel, you'd stipulate to the value being over two.
Yes, Your Honor.
Yes, Your Honor.
All right. Sir, I do have to advise you that if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Absolutely, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes,
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be
May 18th at 9 a.m.
May 18th, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Bond will continue. Thank you, sir.
Thank you.
Court does call the case of the people versus Derek Braddock.
I am here.
Yeah, the people.
Assistant Public Defender Davi Lieb on behalf of Ms. Braddock, and I do have a green sheet.
Okay. Ms. Braddock, did you state your name?
Yes, my name is Derek Braddock.
Do you have a camera, please, ma'am?
No, my camera just currently broke. My son just currently broke it. I mean, my back camera works.
I'm going to adjourn it this time, but if you don't get a camera fix, you can't appear by Zoom. You've got to come down to the courthouse. You understand that?
I understand, yes.
You have not received discovery. Is that the issue?
I have received it as of this morning.
That's part.
I received it this morning.
Got it this morning.
Yeah.
Okay. Probable cause conference will be adjourned to May 14th, 2026, 9 a.m.
Thank you.
Thank you.
Thank you.
Thank you.
You're welcome.
Court does call the case people versus Jason Maples.
Yeah, the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Maples. Mr. Maples is approaching. Would you please state your name for the record, sir?
Jason Gary Maples.
Your Honor, this morning we have been able to finalize a resolution for a plea agreement in this matter, which would allow Mr. Maples to continue in the felony recovery treatment court. We just got the information moments ago that it would be that the plea agreement we are negotiating is appropriate. So we're asking for an adjournment in order to formalize it in writing. There is also a stipulated order for Mr. Maples to be released.
All of that correct?
Yes, Your Honor.
So what I will do is, in fact, using custody, I'll adjourn it out 1 week to 30th, April 30th, 2020.
Thank
Bond will continue. Thank you. Court recalls the case of the People versus Derek Stewart.
And Raymond Cook for the people.
Order, against the public defender, Representative Stewart.
Mr. Derek Stewart.
Mr. Stewart? Okay, thank you, sir. I now have the report. Do the people have any additional evidence?
No, Your Honor, we would stipulate to the report.
We would stipulate to the report as well. I also believe I submitted a proposed order.
Yes, ma'am. The court, in reviewing the report, and that being the evidence, would find that at this time the defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I have signed the order. What would you like to set for?
We would like to set up for a preliminary exam.
Okay. He is there, sir.
Yes, that is correct.
So there's my 3-week date. Say,
May 12th.
is all discovery complete, Ms. Gaines?
That is my understanding.
And would the people have their witnesses available May 12th?
Is that 3 weeks out, Your Honor?
That is 3 weeks.
That should work. We'll do the best.
All right. Preliminary examination in person, May 12th, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you. Court does call the case, People versus Jenny Liu. I'm sorry.
Your Honor, Keith Clark. Oh, there we are. Your Honor, Keith Clark, Assistant Attorney General on behalf of the people.
Good morning.
Good morning, Your Honor.
Brother Judge Torsia, Assistant Public Defender on behalf of Ms. Jenny Lewis, who should be present on Zoom, Your Honor.
You have her?
Not sure.
You're not Hammer.
Your Honor, my office did speak to her yesterday. She indicated she'd be here. I do not know why she's not present. For the record, I'm pushing adjournment, but I do not know where she is.
You're asking for an adjournment. You don't know where she is.
No, Judge.
Go ahead.
Your Honor, we did receive information. I shared it with defense counsel yesterday that Miss Liu, after she was given personal bond, took a flight and left the country. Or not left the country. I'm sorry, left the state. She sent what's called a JPay message to a fellow prisoner, or who was a fellow prisoner at the Department of Corrections. She was hopping on a plane and leaving. I can provide that to the court. We have prepared a protective order. Some of the information in this, some of the discovery in this case would be a threat to community safety or to the safety of the prison. So there is a protective order. Hopefully, counsel has a copy that the court can sign, and when the court signs the protective order, I will provide all the discovery to the defense.
I'm sure we have it in our file, Judge. I can print that out and do it to the
Okay, you can give it to, I understand. And I would sign that protective order, but her not being given the representations, what is a bench warrant for the defense press time because it, the court is going to, that bench warrant will issue no bond.
Thank you, Judge.
Thank you, Your Honor. And Your Honor, I'm sorry, the court issued the bench warrant, and the bench warrant was for no bond?
No bond, sir.
Arraignment. Thank you, Your Honor.
Thank you.
Bond?
Yes. And then immediately. That warrant will issue immediately. Court does call the case of the People versus Abdurrahman. Two cases.
Jacob Kennedy for the people, Your Honor.
Good morning, Your Honor. I'm with on behalf of Mr. Bashir. Your name, please.
Your name, sir?
Abdurrahman Bashir.
Arrest. Ask the court to please set these for exam. Discovery is complete.
Would the people have their witnesses available? We're on the 5th, correct? Would you have their witnesses available the 5th?
Go one additional week. These are rather old cases, and given the length of time that's passed since then, I likely will need to get a new officer charged for these matters to be able to proceed. I already sent it out.
Is there going to be any objection to that?
Yes, and I would just leave it to the court and note the cases are old.
All right. You good? All right. We're tough around here. Anna tripped you. No, I think so too. I'm gonna file charges. All right, you want? Is he in custody on anything else? And the people want the additional time because of the age of the case. Got to get new.
That's correct. 1 7 years old, 1 6 years old. Reason that they are so old to get.
Noting the objection, but also noting that the defendant, that the reason that people have to do what they are doing is because of the defendant's failure to appear. I will give that additional week. I will set these for preliminary examination, discovery being complete. I'll set it for May 12th, 2026, 9 a.m. on both cases. All right, bond will continue.
Which judge is this?
Oh, before Judge, I'm sorry. Before Judge Washington. Thank you. Court does call the case, People versus Darius Cadell.
Your Honor, Raymond Cook for the people.
Got ready, Your Honor. Good morning to you. Good to see you, Matthew Mansour, on behalf of Mr. Cadell, who's approaching. To my right. Mr. Cadell, could you please state your name for judge since Darius Cadell? Your Honor, I have 2 things for you. I have a green sheet and a bond filing. For
yeah, you can get that up to me at some point.
Okay, thank you.
Thank you. You're asking for an adjournment?
Yes, please, Your Honor. I'm going to start the negotiation process. I just got the discovery, the media discovery yesterday, so it's about done.
Why hasn't he gone over to community correction?
Your Honor, I've talked to him about that. And him and his mother, he's had transportation issues. That is not going to happen anymore. He understands.
I know that.
Because I let him know how serious these matters are, that this court is not one to play around with. And he knows that he could potentially be incarcerated for not drug and alcohol testing. Something like this, it can be fixed, and it will be fixed. If you just allow, he will test today, Your Honor.
Gonna test clean?
Sure.
For everything?
Yeah, yes, sir. Even marijuana? Your Honor, 1 second, Your Honor, please.
Okay, well, May 12th, the last street meeting was Washington.
Last time I did it was Washington, Saturday. Your Honor, to be candid with you, to be
really
honest with you, of course.
So what changed that?
Just, you know.
Oh, go ahead. I'm listening.
You got to be honest and upfront with you, Your Honor.
Really?
I know how it is. Yes, yeah.
Oh, that's the problem.
Marijuana traces might appear, but he knows.
Marijuana traces might appear. What's that mean?
He used marijuana a few weeks ago. I don't know if it's in there or not, but just letting you know, just being honest with you. And he knows
So he got out of jail. He's not supposed to be using any drugs. Does he have a medical marijuana card?
No, but he will not use anymore. I didn't use it like the day before. It was before, Your Honor.
Pardon?
It was before. He used marijuana before he got arrested. I didn't use it after. And we can track the level. He's going to comply. I know he will.
I don't know that you can make that representation that you know that he will, because he's not thus far.
I have faith.
Okay.
Your Honor, maybe.
Yes.
You may. All right, record should reflect we had a bench conference in this. And I'll just put it this way, there is, while this might seem minor on this case, defendant is also on, and I'm not going to go into detail, but he's on probationary status at the time of this offense. Part of that probation includes that he should not be using drugs, should not be using anything, shouldn't have been using marijuana at that time. So what I will do is give counsel time to check into that and his potential violation of that probation. I'll adjourn this out 1 week to April 30th, 2026, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded. Yes. Court does call the case People versus Kurt Bushline.
Office for the people.
They may not be able to bring him out.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Bushline, who approaches from the back. Please state your name, sir.
Kurt Bushline.
I have before me a plea form that indicates that the defendant will be pleading to an added count 2 of use of cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There is a sentence agreement to credit for time served and fines and costs. That's the court's full understanding of the agreement.
Correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Right then. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Kurt Bushline.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that? You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th.
Okay. Yes, sir.
Understand that? Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
Signed an advice of rights form or had one signed on your behalf. Is that correct, sir? Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And because you believe that you are indeed guilty?
Yes, sir.
September 22nd, 2026, at the location of 100 South 4th Street, City of Ann Arbor, Washtenaw County, State of Michigan. Did you have cocaine in your possession? Had you used it?
Yes, sir.
Did you know what you were using was cocaine? All right. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in court rules, that would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir? Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be May 8th, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Clay.
That's the office for the people.
Good morning,
And
Your
your-
Honor. Wendy Barnwell, P42505. I believe you may have called Andrea Clay. I only heard.
Yes, that is the one I called.
Okay. Yes, thank you, Judge.
She here? Andrea Clay, she is not here, Miss Barnwell. Much like you. No, I'm kidding. Because you won't come see me. It's okay. My feelings aren't hurt. You have any notion of her whereabouts?
Judge, I talked to her godmother this morning, and I had also I had heard from her godmother had responded. Now, let me say this. I had sent her a text before I saw, at 1 o'clock this morning, I saw that the JA had sent me an email saying that she has to be here physically. She cannot come on Zoom. When I initially sent a text message, I told her she may come in person. I used the word may, but I also gave her the Zoom number, assuming, because I accepted the case recently and I asked for Zoom. So that has happened, where I did. But then this morning, when I saw it, I sent her the text immediately. Then this morning, I called her godmother, and she had enough time to get there. I called early in the morning.
Okay.
So I'd ask that we hold off, but it's within your discretion, Judge.
I know. Thank you. Thank you, though, for letting me know that. Go ahead.
I'm aware that there's a community corrections violation as well. I request bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Thank you, Ms. Barnwell. And at some point, you're going to come back down and actually see us in person, aren't you?
Yes, I had a trial in Ann Arbor that took up a lot of time, and I wasn't taking cases while preparing because it was a big one.
Got it. Okay, well, we'll see you soon.
All right, thank you.
you.
Have a good day, everybody.
Court calls the case, People State of Michigan versus Michael Burge.
Alexander, on behalf of the people, Your Honor.
Courtney, Assistant Public Defender representing Mr. Burge, who is approaching. Your Honor, we are requesting an adjournment for ongoing negotiations. You have a blank sheet.
Two weeks, please.
Yes, please.
Oh, you just find that. All right, probable cause conference will be adjourned May 7th, 2026, 9 a.m. Bond continue.
Thank you.
Yeah.
Thank you, Mr. Burge.
Court does call the cases of the people versus Edward Eugene Harris.
Honor. Fresh. Under Michigan Courtroom 8.120. Under the supervision of Assistant Prosecuting Attorney Alexander.
Finally, she's letting you do stuff, right? No. It's your last day? She's finally letting you do something, but now it's your last day. Good job, Zenda. Well, it's been a pleasure having you before the court. I will say that. And permission to practice is granted.
Good morning, Your Honor. Jonathan Sachs for Mr. Harris in his case ending in 1250.
For show feaster on the remaining cases, Your Honor.
That's right. Is he present?
Got Zoom there, Judge.
Yes, Your Honor. He is.
Mr. Harris, can you state your name, please?
Edward Harris.
What do we do?
Your Honor, we're continuing negotiations. We're hoping to have a good resolution here that should be able to take up all three of his cases.
Yes, Judge. That's accurate. Would be asked for adjournment.
All right.
We request 3 weeks.
Hearing no objection, I'll set it. I got it. Thank you, though, for putting your nose in it. Be adjourned to May 14th, 2026, 9 a.m. Bond continued.
Judge.
Thank you, Your Honor. Mr. Harris.
Court does call the case People versus Deanne Bird.
On behalf of the people.
Hello.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Bird.
Hello, good morning. Morning, your name? John Bird. Thank you. What are we doing?
Your Honor, I did reach out to Ms. Zinda because we did not receive discovery in this matter. I have spoken with Mr. Byrd, who states this is a reauthorization case. So I did, both are. So I did go back to look through our file, and I cannot confirm for one of the cases that we did represent them. I believe it's my understanding from him that we did, but in terms of looking through the file and matching the dates that these have alleged to have occurred. So that's the first thing.
Just so I'm clear, what you're telling me is that you may not have discovery because you may not have been attorney of record on one of these.
Your Honor, I'll make this easier. It was resent yesterday for both files. I didn't realize it was the same in evidence items. We did a new meeting notice that should be released yesterday.
Got it. Okay.
Still not in my file as of last night when we met. I will check again. I have not checked this morning. So I am asking for some time for that, but I would also like to address bond. And if I could have one moment.
So if you're going to get the discovery, here's what I want to also make sure of. I don't mind adjourning it out, doing that, but I want to make sure if Mr. Byrd's indicating that on the previous ones, that the public defender represented, that there's not going to be an issue. What I would like not to run into, if we can avoid it, is all of a sudden you're here on both cases, but now you have a conflict, and then it's put out, and then it's further delayed. But we don't know that yet. Yes.
I do not believe that we have a conflict just based on my review of our representation of him in the past.
Got it.
And that it's the same complainant.
Okay.
We very recently represented him on a probation violation involving the same person as that.
Right. Okay. Then I'll adjourn this out to May 7th.
I was going to say, could we have a shorter period of time? And I will explain that in part. Go
ahead.
Even just a week would be fine. That is because Mr. Byrd is the complainant in a matter involving this same complaining witness. This is a 2024 case. There's currently a matter where he is the victim, and this morning I was able to find that case and make copies of the register of actions for both Your Honor and the prosecutor. And he has been attending all of those court dates, but there is a concern that part of this case was dismissed in 2024. And I was able to confirm, as my client told me, that just before the meeting with the friend of the court in their divorce /custody proceeding, that the complainant came to the Washtenaw County Prosecutor's Office almost 2 years later, asking to have the matter reauthorized. As it states in the report, that does not mean it's not any less serious, but it is an interesting state of affairs. And he has a pretrial on the matter where he's the victim. He's been attending each of the case, all of the hearings.
That case?
That is in Wayne County, and that is on May 8th. And like I said, I was able to print that out for Your Honor and the prosecutor this morning when I found that.
And I want to say for the record, I spoke with the victim myself before reauthorizing this case, and she indicated to us that at the time these cases were dismissed, she was extremely terrified with the defendant and was not comfortable proceeding. She now has a better support system around her, and he had continued to harass her in the time since these cases were dismissed, and now she felt more comfortable and safe proceeding, and that is why these cases are now back before the court.
I also have, and I did not, because I'm not trying to retry the custody case, but I do have the recommendation where she speaks about what a great father he is and all of those things. So I wanted to
address terrible maid.
You
right?
Can be.
That's it. So I don't know what that has to do with it.
But
I'm not a family court, so I don't know what that means.
But my point being is that I'm only trying to address these as far as bond and to have a court date next week so that he will be available to go to the pretrial hearing for the case where she hit him with her car.
Allegedly.
Allegedly.
Thank you.
Yes, yeah.
So
Well,
that's set for the A.
that is set for the 8th. So if we could have a 1-week adjournment.
All right. Any objection to it?
The discovery was sent yesterday, so we should have everything.
We'll adjourn it 1 week out to the 30th.
And Your Honor, we would ask that the court, considering how old this case is, and that in terms of since that case was dismissed in 2024, there have not been any allegations or cases as far as Mr. Byrd. The only cases have been I believe there are 2, but definitely this one pending, where Mr. Byrd is allegedly the victim. And so with that, I believe that he can abide by any orders, no contact orders, or whatever the court would say would be appropriate, so that he can continue to not only pursue this case, but also his rights as related to being a victim in the other case. And so we're asking for personal recognizance.
I'm going to object. This is 2 cases of aggravated stalking. In these cases, it includes threats to the victim that include the defendant texting her, "If I see you in Ipsy, I'm walking you, bitch. Don't be home. You need to learn to keep my name out of your mouth." That he will, everyone in the victim's car with her will get hit. And then this case came back to us with the victim because she informed us, and this was in a Washington measures report that is going to be edited with a related report, in which he was still continuing to harass her, showing up to her unit unannounced and calling her, looking at her social media posts. And that is why this case is dead. So I do have concerns for persons, given that even when the were dismissed, that pattern of harassment did continue. And I have concerns for her safety.
You know, there's no allegations of any of those things since 2024. These are allegations from that case from 2024. We have not had any cases come forth. Pardon me?
That's not what I'm hearing.
December of 2025, that was in a different case that I somehow didn't get added onto this one as a related report. That includes allegations of him coming to her unit in 2025, December of 2025, and continuing to harass her. So I will add that and get that sentence today.
Your Honor, that was after those other matters were dismissed, and there continue to be parents together. But if the court implements an order, a no contact order, then he will abide by that order.
Since I'm adjourning it out the 1 week, 30th, I'll just adjourn it out there. At this point, I'm going to deny the motion for bond reduction or modification of bond. Let you take a look at that other report, see whether or not that other report is relevant to the bond argument.
Thank you.
Thank you. Court calls the case, People versus Jeremy Shue.
As thoughts for the people.
Good morning, Your Honor. Jonathan Sachs for Mr. Shue.
That's the one.
I believe he is on Zoom.
Have it. Oh, he's the scales of justice. Mr. Shue, really? Okay. Jeremy. I'll pass it. We'll see if he'll show up.
Thanks, Your Honor. I'll get in touch with him right away.
Court does call the case, People versus Antonio Guyton. Oh, they're not up yet. We're to pass that matter briefly. Let me.
There.
Court does call the case of the People versus Antoine Thomas.
As thoughts.
Albert L. for Mr. Thomas, who should be logging in Zoom. I know he's having some trouble earlier. Judge, can we pass the matter? I know he's been trying to log in, but I guess he was having some trouble.
I'm here. Just trying to figure out how to turn on camera. Can you hear me now?
I can hear you. Can't
Okay.
see you.
Okay, let me see. Let me see.
Oh, that's Jeremy.
No, it says Antoine Thomas was.
That wasn't Mr. Shu. I see Mr. Shu on the screen. That wasn't Mr. Shu. That was Mr. Thomas.
Hey. Can you guys see me now?
We can see you.
And Antoine, if you could please state your name for the record.
Antoine Thomas.
Your Honor, your Honor should be in possession of.
I have a plea sheet in front of me that defendant is going to be pleading guilty of a controlled substance, a 1-year offense. On his successful plea to that charge, count 1 would be dismissed. I also have a sentencing agreement between the parties. Prosecutor's deferred sentencing. That's the court's full understanding of the agreement.
That's correct, Your Honor. Thank you.
Yes, Judge, that's correct.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name again for the record, please.
Antoine Thomas.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of use of, which drug are we talking about? Cocaine?
Yes.
Yes.
Okay. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge and you would sentence before Judge Garwood in the 15th District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up all the rights, particularly the rights under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of rights.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you're guilty of this offense?
Yes.
September 15, 2025, at the location of Boardwalk Drive, City of Ann Arbor, Washington County, State of Michigan, did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, I have.
And did you know what you were using was cocaine?
I was aware. Yes.
Okay. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Absolutely. Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
I am not.
And have I complied with the court rule?
People are satisfied.
You have.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
May 12th at 9 a.m.
May 12, 2026, 9 a.m. before Judge Garwood. Bond will continue.
Thank you, Judge. We'll be in touch, Antoine.
Okay. Thank you, Kyle. Have a good day.
Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Antonio Guyton.
Again, Your Honor, agreement for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Guyton. You're doing some. Your Honor, this morning, Mr. Guyton will waiving the preliminary examination. We've submitted a preliminary examination form waiver.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution. People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with counts 2, 3, and 4 follow.
What is good? I'm so sorry, what was that?
What our constitutional for?
What was that? Was it a mistake? Okay. Joy, pardon me. Your Honor, we acknowledge receipt of the information, waive its reading on the record, and at this time, my client wishes to stand mute and have the court enter a not guilty plea in his behalf.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all 4 counts. Pretrial will be set for
May 4th at 1:30 with Judge Hamud.
May 4th, 2026, 1:30 before Judge Hamud. Bond will continue.
Your Honor, we have also submitted a
I signed it.
late order. Thank you so much. So he signed the order regarding treatment.
Thank you.
Thank you.
They need to stand. Court recalls case People versus Jeremy Shue.
That's all for the people.
Thank you, Your Honor. Jonathan Sachs for Mr. Shue.
Jeremy Shue.
Now,
Thank
As
you,
soon
Jeremy.
as you called my case last time, it kicked me out of the Zoom hearing, Your Honor. I'm sorry.
It did?
Yes, it did.
I probably did that on purpose. I'm kidding.
At this point, I wouldn't be surprised, but not you.
Listen to you.
This courtroom session showed one thing clearly. The system doesn't slow down for anyone. Case after case, people stood in front of the judge, some asking for more time, some trying to delay, and others ready to plead guilty. But the judge stayed focused on one thing: moving forward. In one moment, a defendant tried to rush the process, asking for a quick resolution, but the judge made it clear, without proper evidence and preparation, the case cannot just disappear. In another case, someone didn't even show up, and just like that, a bench warrant was issued with a $25,000 bond. No warning, no delay. Then came another reality. Violating probation, missing conditions, or even small mistakes like drug use can instantly change everything. One decision, one action, and your bond can be revoked, leaving you in custody. Because in court, timing matters, preparation matters, and most importantly, showing up matters. So here's the real question. If one missed step can lead to a warrant or jail, why do people still take that risk? Like and subscribe for more real courtroom moments.